Hello, my name is Harman and I am teaching law at the University Institute of Legal Studies, Punjab University, Chandigarh. Today we are going to be discussing the topic of Directive Principles of State Policy as enshrined in the Constitution of India. The Constitution of India aims to provide not only a political democracy but also seeks to provide for socio-economic justice in order to ensure the welfare of the people. To achieve this cherished objective, it has included certain guidelines and principles which are to be followed by the state in governance of the country. The Directive Principles of State Policy as incorporated in Part 4 are meant for the state to follow in matters of administration and in making of laws. Hence, it is the duty of every responsible government to translate these directives into action in order to ensure socio-economic development of the people. Now, the learning outcomes of this module are, first of all, the learner should be able to describe the significance of the Directive Principles of State Policy and the object behind their incorporation in the Constitution of India. Secondly, to understand the various directives as provided in Part 4 of the Constitution. Thirdly, explain the relationship between directive principles and fundamental rights. Therefore, these are the learning outcomes that are intended to help the learners get a better understanding of the topic of Directive Principles of State Policy. We will start by discussing the concept of Directive Principles. Part 4, comprising of Articles 36 to 51 of the Constitution, contain the Directive Principles of State Policy. The Directive Principles of State Policy, as enshrined in Part 4 of the Constitution, outline the aims and objectives that a state shall follow in matters of administration and in making of laws. The idea to have such principles in the Constitution has been borrowed from the Irish Constitution. The directive principles are the ideals which the government must keep in mind while formulating policy or passing any law. They embody the aims and objectives of a welfare state. Now we will discuss what was the need for incorporation of a chapter on Directive Principles of State Policy in the Constitution. Now, the main objective behind incorporation of Directive Principles of State Policy in the Constitution appears to have been to set standards of achievement before the legislature and the Parliament of India. Today, we are living in an era of a welfare state where the state seeks to promote the prosperity and well-being of the people. The makers of the Constitution had realized that in a poor country like India, political democracy would be nothing without economic democracy. Therefore, the Directive Principles of State Policy strengthen and promote this concept by seeking to lay down some socio-economic goals which the governments of India, both at the centre and the states, have to strive to achieve. In a number of pronouncements, the Supreme Court has time and again insisted that directive principles seek to introduce the concept of a welfare state. The directive principles can be broadly classified into three categories. The first being Social and Economic Charter, the second being Social Security Charter, and the third being Community Welfare Charter. First, we will discuss the Social and Economic Charter, which comprises of Articles 38 and 39 of the Constitution. Article 38 provides that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, economic, social and political shall inform all the institutions of national life. Clause 2 of Article 38 provides that the state shall in particular strive to minimize the inequalities in income and endeavour to eliminate inequalities in status, facilities and opportunities not only amongst individuals but also amongst groups of people who are engaged in different vocations or residing in different areas. What Article 38 provides is a directive which reaffirms what has been declared in the Constitution of India, that is, the function of the Republic is to provide justice, social, economic and political. To secure the justice to the people under the law, courts with broad powers have been established throughout the country. The Supreme Court has observed that if a law is made to further socio-economic justice, it is prima facie reasonable and in public interest. In other words, if it is in negation, it is unconstitutional. Now we will discuss Article 39. Article 39 states that the state shall in particular direct its policy towards securing certain principles of policy which are required to be followed by the state in matters of administration or in making of laws. The first directive which has been given is that the citizens, men and women equally, have the right to an adequate means of livelihood. Secondly, Article 39 says that the ownership and control of the material resources of the country are so distributed as best to subserve the common good. Thirdly, the operation of the economic system does not result in the concentration of wealth to the common detriment or to the concentration of means of production to the common detriment. Fourthly, Article 39 says that there shall be equal pay for equal work for both men and women. Fifthly, that the health and strength of workers, both men and women, and the tender age of children shall not be abused, and that citizens shall not be forced by economic necessity to enter avocations unsuited to their age or strength. And finally, Article 39 says that the children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and all kinds of material abandonment. The Supreme Court has taken recourse to Article 39A to interpret Article 21 to include the right to livelihood within the purview of Article 21. The Supreme Court has observed in Olga Tellis versus Bombay Municipal Corporation, and I quote, "If there is an obligation upon the state to secure to the citizens an adequate means of livelihood and the right to work, it would be sheer pedantry to exclude the right to livelihood from the content of the right of life." In a major pronouncement in Madhu Kishwar versus State of Bihar, with a view to protect the economic interests of the tribal women depending on agriculture for their livelihood, the Supreme Court has ruled that on the death of a male holder of the agricultural land, the dependent female members have the constitutional remedy of continuing to hold the agricultural land if they are depending upon that land for their livelihood. Otherwise, the females will be rendered destitute. Again, Articles B and C relate to significant constitutional provisions as they affect the entire economic system in India. We are living in an agrarian society where agriculture constitutes the main component of the economy. Therefore, in keeping with the requirements of Article 39B and C, certain laws have been passed in various states, keeping a limit on the ceiling of keeping a limit on the land which is held by the various landlords. They are the land ceiling laws which have been provided by the various legislations as enacted by the states in India. In state of Tamil Nadu versus L. Abu Kavur Bai, upholding the nationalization of stage carriages, the Supreme Court has given an expansive interpretation to the word distribution used in Article 39B. The Supreme Court has held that the word distribution does not merely mean that the property of one should be taken over and distributed amongst the others, in order to ensure that there are land reforms where the lands from big landlords are taken away and given to landless laborers. That is only one of the modes of distribution, but not the only one. Article 39C contemplates measures for preventing concentration of wealth and means of production in a few hands. Parliament has enacted Equal Remuneration Act 1976 to implement Article 39D. Next charter that we will discuss is the Social Security Charter. Social Security Charter comprises within itself 8 different directive principles of state policy. The first one being Article 39A, which provides for equal justice and free legal aid. It provides that the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any person by reason of economic or other disabilities. Article 41 provides the right to work, to education and to public assistance in certain cases. It states that the state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education and to public assistance in cases of unemployment, old age, sickness and disablement, and in all other cases of undeserved want. By reason of this directive, the state has been put under a duty to ensure that all the citizens are given the right to work, to education and to public assistance. Article 42 provides for a provision for just and humane conditions of work and maternity relief. It provides that the state shall secure just and humane conditions of work for all the workers and also for maternity relief. In Bandhu Mukti Morcha versus Union of India, the Supreme Court read Articles 21 and 23 with directive principles of state policy as enshrined in Article 39E and F and Article 41 and 42 to secure the release of bonded labor and free them from exploitation. The Supreme Court has observed that this right to live with human dignity is enshrined in Article 21 and which derives its life breath from the directive principles of state policy and particularly Articles 41 and 42. It is not only the question of release of bonded labor but also their proper rehabilitation after release. The Supreme Court in this case insisted upon effective rehabilitation of the freed bonded labor families. The next directive is enshrined in Article 43, which talks about living wage for the workers. It says that the state shall endeavor to ensure by suitable legislation or economic organization or in any other way work, a living wage, whether the worker is an agricultural worker or an industrial worker, conditions of work ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities, and in particular, the state shall endeavour to promote cottage industries, whether on an individual or a cooperative basis in the rural areas. Therefore, by way of this article, the Constitution has made it a reasonable restriction upon the freedom of business under Article 19(1)(g) to provide that an employer must pay a minimum bonus to his workmen even in a year in which loss has been sustained. 43A talks about participation of workers in management of industries. It says that the state shall take steps by suitable legislation or in any other way to secure the participation of workers in the management of undertakings, establishments or other organizations engaged in any industry. In a capitalist economy, the means of production as well as the profits and the losses are borne by the capitalist. Workers are only employed and they receive wages for the work done. Under a socialist economy, there is no place for a capitalist because all means of production together with the management are held by the state. But socialism doesn't believe in any violent transition from capitalism to collectivism, but believes in a phased transition. Article 43A is the first active step towards socialism in India. After having inserted the word socialist in the preamble by the 42nd Amendment Act 1976, it was considered necessary to include this directive. The scheme of Article 43A is that though the ownership might belong to a private individual or the state, the workers engaged in a particular industry or enterprise shall, by legislation, be given a share in the management thereof. Article 45 of the Constitution provides for provision for early childhood care and education to the children below the age of 6 years. Now, this article was substituted for an earlier article in 2002 by the Amendment Act of 2002, which was the 86th Amendment Act. Earlier, Article 45 provided for right to education to the children up to the age of 14 years. In Unnikrishnan versus State of Andhra Pradesh, Supreme Court held that the right to education of the children up to the age of 14 years is included in the right to life as enshrined in Article 21. Therefore, in 2002, by way of the 86th Amendment Act, Article 45 was substituted for the earlier one. The law that remains today is it provides for a provision for early childhood care and education to the children up to the age of 6 years. Therefore, it is a directive which has been provided to the state in order to ensure that tender age of children is taken care of. Article 46 provides for promotion of educational and economic interests of scheduled castes, scheduled tribes and other weaker sections. By way of this article, the state is required to promote with special care the interests both educational and economic of the weaker sections of the society, and in particular the scheduled castes and scheduled tribes, and it is for the state to protect them from social injustice and all forms of exploitation. Article 47 provides duty of the state to raise the level of nutrition and the standard of living and to improve public health. It is required by the state to regard the raising of the level of nutrition and the standard of living of the people and improvement of public health as amongst its primary duties, and in particular the state is required to endeavour to bring about prohibition and consumption except for purposes of intoxicating drinks, except for medical purposes of intoxicating drinks and of drugs which are injurious to health. It has been held by a full bench of the Madras High Court that these words contemplate the use of liquor or alcohol for the making or manufacture of medicinal preparations and does not contemplate the free use of intoxicating drinks as medicine. Article 47 casts a duty on the state to reduce liquor consumption. Next charter that we will discuss is the Community Welfare Charter. And the first directive under the Community Welfare Charter is enshrined in Article 44 of the Constitution, which deals with Uniform Civil Code. Article 44 provides that the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. The objective of this article is to effect national integration by bringing all communities on a common platform on matters which are at present dealt with by the personal laws. For example, divorce, maintenance, marriage. It is based on the concept that there is no necessary connection between religion and personal law in a civilized society. The Supreme Court has repeatedly regretted that Article 44 has so long as remained a dead letter and recommended early legislation to implement it. A common civil code will help the cause of social and national integration by removing the contradictions based on ideologies. Article 40 of the Constitution provides for organization of village panchayats. It says that the state shall endeavour to provide for organization of village panchayats and also endow such panchayats with powers and authorities as may be necessary to enable them to function as units of self-government. The next article is Article 48, which talks about organization of animal husbandry and agriculture. It says that the state shall endeavour to organize agriculture and animal husbandry on modern and scientific lines and shall in particular take steps for preserving and improving the breeds and prohibiting the slaughter of cows and other milch and draught cattle. It is in keeping with the Hindu sentiment regarding cows that Article 48 has accorded recognition to this sentiment. Under Article 48, a total ban on cow slaughter is possible, and this position has been accepted by the Supreme Court in Qureshi's case. While the test of usefulness has to be applied in extending protection to other animals, it is not to be applied to cows. This is criticized by many as anti-secular and uneconomic. Article 48A provides for protection and improvement of environment and safeguarding of forests and wildlife. It says that the state shall endeavour to protect and improve the environment and to safeguard the forests and wildlife of the country. The Supreme Court has clarified that whenever a problem of ecology is brought before the court, it is bound to keep in mind Article 48A, which provides for protection and improvement of environment and safeguarding of forests and wildlife. The least that the court may do is to examine whether appropriate considerations are borne in mind and irrelevance excluded. The next article talks about protection of monuments and places and objects of national importance, which is Article 49. Article 49 says that it shall be the obligation of the state to ensure that the monuments or objects of historical or artistic importance are protected from being spoiled or exploited, which have been declared to be objects or monuments of national importance. Therefore, by way of Article 49 directs the state to protect every monument or place or object of artistic or historic interest declared by or under any law by Parliament to be of national importance from spoliation, disfigurement, destruction, removal, disposal or export as the case may be. Next, Article 50 provides for separation of executive from the judiciary. The state shall take steps to separate the judiciary from the executive in the public services of the state. Because Article 50 is based on the bedrock of the principle of independence of judiciary, therefore Article 50 provides for a very important directive. It requires the state to ensure that it takes steps to separate judiciary from the executive so that there is no interference with the powers exercised by each. Article 51 talks about promotion of international peace and security. Under Article 51, Constitution requires the state to endeavor to, first of all, promote international peace and security. Secondly, maintain just and honorable relations with other states. Thirdly, foster respect for international law and treaty obligations in dealings with organized peoples with one another. And fourthly, to encourage settlement of international disputes by arbitration. Justice Sikri has observed in Keshwanand Bharati vs. Union of India as regards Article 51 that it seems to be that in view of Article 51 of the Constitution, this court must interpret language of the Constitution, if not intractable, which is after all a municipal law, in the light of the United Nations Charter and solemn declaration subscribed to by India. The next major topic that we will discuss is the justiciability of the directives. Are the directives enforceable? This is the question that we are going to try to find an answer to. The answer lies in the Constitution itself. Article 37 of the Constitution provides that the provisions contained in this part shall not be enforceable by any court, but the principles therein contained shall be fundamental in the governance of the country, and it shall be the duty of the state to apply these in making laws. It follows from Article 37 that directive principles are non-enforceable and non-justiciable. They confer no rights on any person to redress the grievance in case he has any against the state if the state does not fulfill any duty that it has been put by the directive principles of state policy. Now, the reason behind the legal non-enforceability and non-justiciability of the directive principles is that they impose positive obligations on the state. It is for the state to see as to whether it is in a position to fulfill the directives as enshrined in the Constitution, and the state in matters of administration as well as in making laws suffers from many restraints, the most important one being financial restraints. Therefore, it would not be possible to expect the state to always ensure that all the directives are being fulfilled. The next main question that we will try to assess is the relationship between directive principles and fundamental rights. What kind of relationship do they have? The directive principles, first of all, differ from fundamental rights, which enjoin the state to refrain from taking prejudicial action against an individual and thus impose a negative duty on the state. Directive principles impose a positive duty on the state, and fundamental rights impose a negative duty on the state. Directive principles differ from fundamental rights in the following respects. First of all, the directives are not enforceable by any court in India. by virtue of Article 37 of the Constitution. However, fundamental rights are enforceable by virtue of Article 32 and 226 of the Constitution of India. Secondly, the directives are required to be implemented by legislation, and so long as there is no law carrying out the policy laid down in a directive principle, then the state cannot be required to implement any directive principle. However, fundamental rights are the rights which are available to the citizens by virtue of them being the citizens of India, and those are basic and inalienable rights which cannot be taken away from the citizens. Thirdly, the directive principles per se do not confer upon or take away any legislative power from the appropriate legislature. Legislative competence must be sought from the legislative lists contained in the 7th schedule of the Constitution. Fourthly, the courts cannot declare any law as void on the ground that it contravenes any of the directive principles. The courts are not competent to compel the government to carry out any directive. However, the court can compel the government not to abrogate or infringe the fundamental rights available to the citizens of India. The Supreme Court in Champakam Durai Rajan has held that the directive principles should confirm and run as a subsidiary to fundamental rights. The fundamental rights would be reduced to a mere rope of hand if they were made non-enforceable or could be overridden by the directive principles. In course of time, a perceptible change came over the judicial attitude regarding the relationship between directive principles of state policy and fundamental rights. And the courts have time and again given a harmonious construction to the relationship between the two. The courts have adopted the view that in determining the scope and ambit of fundamental rights, the directive principles should not be completely ignored, and they should be kept in mind while interpreting fundamental rights. Without therefore making the directive principles justiciable as such, the courts began to implement the values underlying these principles to the extent possible. The Supreme Court began to assert that there is no conflict on the whole between fundamental rights and directive principles, and they complement and supplement each other. This aspect of the directive principles was stressed upon by the Supreme Court in Golaknath's case. The Supreme Court there emphasized that the fundamental rights and the directive principles of state policy formed an integrated scheme which was elastic enough to expand to the changing needs of the society. In another landmark judgment, in Keshwanand Bharti versus State of Kerala, the Supreme Court observed that fundamental rights and directive principles constitute the conscience of the Constitution. There is no antithesis between fundamental rights and directive principles, and each complements the other. The Supreme Court in State of Kerala versus N.M. Thomas observed that the directive principles and fundamental rights should be construed in harmony with each other, and every attempt should be made to resolve any apparent inconsistency between the two. In another landmark judgment, the Supreme Court has observed in Olga Tellis that since the directive principles are fundamental in the governance of the country, therefore they are also fundamental in interpreting the meaning and content of the fundamental rights. In Minerva Mills, Justice Chandrachud observed that the fundamental rights are not an end in themselves but a means to an end. It was further observed in the same case that the fundamental rights and directive principles constitute the core of the commitment to social revolution, and they together constitute the conscience of the Constitution. The Indian Constitution is founded on the bedrock of balance between fundamental rights and directive principles. If we give primacy to one over the other, it would disturb the harmony of the Constitution. And this harmony and balance between fundamental rights and directive principles constitutes and is a part of the basic feature of the Constitution. The theme that fundamental rights are but a means to achieve a goal indicated in the directive principles, and that fundamental rights must be construed in the light of the directive principles has been advocated by the Supreme Court time and again. The next topic that we will discuss is Article 31C and the directive principles. What does Article 31C say? Now, this article was added by the 25th Amendment Act 1971. The article has considerably enhanced the importance of the directive principles. Under Article 31C, the first part provides that no law which is intended to give effect to the directive principles contained in Article 39B and C shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or 19. The second part of Article 31C provides that no law containing a declaration that it is for giving effect to such a policy can be called in question on the ground that it does not in fact give effect to such a policy. The validity of Article 31C, the first part, was upheld in Keshwanand Bharati's case, but the validity of the second part of Article 31C was struck down as unconstitutional. Article 31C was again amended by the Constitution 42nd Amendment Act 1976. The amendment further widened the scope of Article 31C so as to cover all the directives. For the purpose, the amendment substituted the words all or any of the principles contained in Part 4 for the words the principles specified in clauses B and C of Article 31. Therefore, now the 42nd Amendment Act gave primacy to all the directive principles over the fundamental rights enshrined in Articles 14, 19 and 31. Now, this had to be called in question somewhere. So, in Minerva Mills versus Union of India, the Supreme Court by 4-1 majority struck down Article 31C as amended by the 42nd Amendment Act as unconstitutional. To conclude, I would like to say that while fundamental rights have served in protecting the rights and liberties of the people of the country, directive principles have provided certain guidelines and principles that have to be followed by the state in the governance of the country, which is an extremely essential provision to be incorporated in the Constitution. Thank you.